Abusiafo asɛm no enya agita dia ye mame Akosua Serwaa Lawyer Judicial Serwaa enei watimi abe kokuden edi nsɛm bi ababonten a master plan motion so down come bia no omode be kokuden akọ appeal na first mistakes ya omoye na omonhwe sesa mistakes no ebi betimi happy bimti so far watimi akokuden akasa ye kwa kofa nanum die nsem no etimi abrel ne die ko ene die ba lawyer Serwaa Judicial wo United Kingdom wono eho ena mami ewa abrinya no otimi eboa na afiso otimi make master plan a odebeboa ne mami Akosua Serwaa na appeal obekọ no bibia ebetimi aye successful etso ede amano enti enya konya na yenkotie lawyer nanum die nsem a watimi edi atudwa.
Contradictions, lack of authentication or identification, and lack of certification, Exhibit B, B1, and C are hereby rejected as they have no probative value and would not be considered for the purpose of providing any civil marriage between the plaintiff and the deceased. Now to the paragraph 107. The court has the right to accord the said exhibit any probative weight. The law is settled that if inadmissible evidence has been received with or without objection to you, Mamin can't have you, Mamin such a 107 need you. Or say the court has the right not to accord to the said exhibit any probative weight. The law is settled that if inadmissible evidence has been received with or without objection, it is the duty of the trial judge to reject same when giving its judgment or ruling and to determine the weight to be accorded such documents when giving its judgment. Last part. And it is not, and if it is not rejected by the trial court, it will be rejected on appeal. This is because the duty of the court is to arrive at their decisions upon legal evidence only, especially so where the counsels for the defendants objected to them. I don't know if you understand as you explain this. Lawyers.
I'm not lawyers, man. Explain it, please. Jemima, how?
So is he?
No, I'll let lawyer Botan explain it, and I'll continue with my view. For me, let me make something clear. So, if you look at the substantive matter before the court, and if you look at the, there is where you could critique in different angle. But there's a reason why you have case management process. There's a reason why you prepare for hearing. And so to me, at some point through the preparation for hearing, if you believe that because of the lack of authentication, you are not going to place any probative value on the evidence before you, of course the judge can still accept it and then later do so. But it is just unfair to make that judgment at preliminary stage, rather than make that judgment at the final stage. Because maybe if the judgment was made at the preliminary where they were doing case management, etc., then there would not be an presumption that the information has been accepted by the trial judge, and therefore the burden has been shifted. Because if you did carefully listen to or watch the proceedings, the other side, the defendant, had plans to introduce a witness, okay, which is the defendants were going to introduce a witness because they believed they had information that they could get to suggest that the marriage between Dagalumba and Akosua Serwaa had dissolved and the documents were forgery. So they were bringing somebody, and that's what they had asked. They had asked to bring somebody from the embassy or a lawyer from the embassy to testify to that effect. And then they withdrew on the Tuesday or the Wednesday before, they had a break on Thursday and the judgment came on Friday. So to me, the judge accepted it, and there was this presumption that they were going to prove that the documents was forged. They were going to bring this lawyer evidence. So if I was from the way, and I said I practice in UK, so that could be totally different. But from UK practice in court, it's reasonable to presume the judge has accepted the evidence, and the burden has shifted to the other party who had already agreed that they were going to provide that additional evidence. That is my view on it. And because it had been tendered and had been accepted, the burden should have shifted to the defendant who had assumed the burden to prove it is forgery. Or at the preliminary stage, the case management stage, the judge should have clearly struck it out and said that it needs to go through the process. So either adjourn the case, stay the case until the document go through the process. So that is my view on it. But
Juma,
yeah.
let me read paragraph 88 for you for the avoidance of doubt.
I read the whole judgment a few times. But
yes, okay. So I'm just using this to answer what you're saying, because the judge actually rejected the document.
Oh, baby daddy, the whole point of her is she feels lawyer Kusi made it known to the judge from the jump, say or invite you will be from I don't know, from whether Germany or the German embassy. And a judge in the car say you're wrong. A judge in the car say it's like only be dealing with it, so they should let it go. Me personally, I would say it could be known to the public where we have a tape and I say a transcript of the whole verbal communication. But I say it's not previewed to anybody. And no, some way, somehow, people feel say, yeah.
No, I'm sorry.
Yeah, and no, I mean some way, somehow, no transcript, no, which we speculators and spectators are not privy to it, no. And no, we are praying and we are hoping that enkoyesa nenka omoma appeal nemremono. Because no matter how you argue, these things are not in the verdict. You can't defend it, my friend, baby daddy. We all support somehow, some way, somehow. But immediately, we say lawyer Kusika say. Judge Nekache lawyer Kusi says he will take charge from there. No, there's no way in a verdict you can prove the person wrong. Because you don't have the transcript and not everything was recorded in the judgment. Of course, it wasn't everything, but the necessary points were included in the judgment. And this lawyer Kusi can make a case out of it. So no, you catch and say lawyer judge Nekache and say like obey bibia for honwanye bibia for. Granted, that would be the best thing for the appeal. They have every reason to go for appeal based on what the judge said. But then again, the good thing also is that they have transcript, they have recordings of the proceedings.
Story. A lawyer such transcripts is a public information.
That part I really don't know.
Court records, maybe I don't think so. You can just apply for.
Yeah, that part I don't know because it contains videos and audio.
Unless who are part to do the case and you can apply for the records. Maybe they say that you are lawyers for this one in this case and you want the records, right? Of the whole and you're able to know the amount. Fine. And now say if you are Ulusu case, no. If you are a lawyer, we won't be so better. So if you are appointed me as a lawyer, may I prepare records in now also. Because there are cases to one man. Baby, that even will be a loose.
Saying what document to me, what I mean,
and that I might check. And that why a real? Our last 3 comments, why a real? Baby, that do I stagnant? So be a cast some young or they are fell so they are right. Because baby, that win him. If time no more court, no more pound banner, or more bemain in Tremuno. I remember on Eka 2 days from maybe now. The tickets are some day here or no. We now appear, almost say judge and say, no more on one position. Some more guys are 17. It's meaning say like Jumana Eka. If from onset, no problem war. Certification issue na there no. And at least, say magnitude of the issue. And at least. It is our back catch on so you are not starting a case or something. But mama assurance say you know the process and you can help this and then you come back and say One thing you maybe I say, Charlie, stop. Boom. Stop. What I want to ask.
Can I just clarify something? There's two things about the expert from the embassy. So lawyer Chrissy specifically asked for an expert to be called from the embassy. So he wanted an order so they can be called. And the judge said, "Oh, we've done this in another case. They don't really want to turn up, and we don't need it. It's not relevant." But also, like I said, the other party asked to. They said that they were planning to bring a witness. A witness themselves who would verify, for example, that there is no marriage, and they would, just that the certificate's not valid. Because if you recall, aside from the marriage certificates and the certified copy and the original coming in, they also had confirmation from the embassy that on their record, on their system, they've been able to confirm that the marriage is still subsisting and that they were still married before Charles Fosu passed away. So that is the reason why I think, as a lawyer, if you have all of this going on, and there's a whole element of the other party bringing evidence to disprove that there is a marriage, then I think that's a mistake maybe they made, but there is a reasonable presumption that the judge has accepted it, and now the burden has shifted to the other party, who said that they were going to prove it by an expert witness. Sorry, go on.
Yeah, so the whole point, I've always said like Akusi did a good job, and somehow I'm not too, unless sometimes you have Boating here who can be sometimes, and I like his fairness. Or ever since me Kojina platform here, like was sticking to what was on the judgment on your area. Like Akusi, I could have asked for a trial, like could have asked for appeal, even when the case was going on. Immediately, some pastor can't say. Okokan and a judge in the tone also say obey say Jumana. Like Akusi could have paused the case and seek for appeal. Someone else can't say with chairman, why are you not doing it, but you are bringing the judgment? That's where I have my problem with Lawyer Akusi. And lawyer, unless you prove me wrong, say we can still have an appeal when the case is going on. But Lawyer Akusi didn't do all that. Into sometimes
in your
motion moment and also file it. So we're really on it and so on.
Let the lawyer try.
Only thing ultimately appealing whilst the case is going on in interlocutory motions. So it be a motion to do this, motion to do that. Say it be a court near we mami. Within the case that per se we maybe one yet. Why you meet me appeal a higher court?
yes, and American say, no, sadly, man, and then because judge, or say when Serwaa was talking, she says the judge told Lawyer Akusi that I will do it. So if you are not doing it and you are passing your judgment, no, I wouldn't accept the judgment because you told me you would do it. So why didn't you do it? But you're going to make your final verdict. And then America said Lawyer Akusi could have put a hold on the whole case. Say you told me to do this, but you told me you would do this, but you didn't do it. So why are you making a judgment? I don't know, say no so can be. I mean, supposedly say no so can be one of the key or now one of the loopholes they are using for or more appeal there. But he could have done a great job.
Lawyer Akusi did not file a motion. A case which is being done in 2 weeks. Go file a motion now. Motions don't motions no. File a motion beyond my you come with a leave because once that motion is straight to. Obesiki leave from court to file the motion because I don't know no obese court or one year. Usiki leave I feel one motion for the leave and you file another motion for the thing itself. Me as I'm day to move that motion. So time is no woman the beginning is a case we know be able filing motion papa be.
And Paul, that's the problem. I think I think that's what it is, lawyer, but is that everybody had been forced by the time.
Some people raise the argument from our side when I'm talking about OB side and they say the judge said it in one of or also sword, say because of certain reasons and the documentation which wasn't right, If he said judgment, he will make it after the year. Like no persuading in January, but Lawyer Akusi says, everything look all right for him, so they should go ahead. That's one of the speculations quite out to.
No, I don't have the transcript. Can I ask a question? Let me just respond to that one quickly, and then I will please. I'm sorry. What happened is that they asked Lawyer Akusi to move fast with his interrogation of the last witness. If I'm making, that's what because if they did not finish with the last witness, then she will not be able to give a judgment until January.
Silva,
You
when
understand?
I listened to Lawyer Kusi yesterday, I don't think there was nobody rushing Lawyer Kusi. Lawyer Kusi made emphatically said.
We had people reporting back.
But
What
I'm saying,
happened is
may from Lawyer Kusi's own mouth, which I listened yesterday, maybe in your time, yeah, I go through this case a little bit because of certain things. I mean, Lawyer Kusi made it say, oh, yeah, you should tell me to say, oh, yeah, Posano. It was your opinion, you say, last person now, about the Posana, and yeah, lawyer. No, that Lawyer Kusi was okay with the timing.
No, let me make something. I think maybe you're mixing it. What happened is that the judge gave the judge.
No, that's not the point Silva is coming from.
Yeah.
Okay, I said it before because the judge made a statement that if he is not snappy, I don't know if the right word I could use for proceedings in court, she might not be able to give the judgment in 2025. It's going to extend to the next year. So I felt like there was a subtle, like kind of coercion that you just have to get over with it.
Exactly.
I'm saying that.
Because there's no injunction. This is what I'm saying.
Exactly. She is coming from that point, Starrett. That's where Silva is coming from.
But who would have benefit from that? Though?
No, because there's no injunction in the funeral. Mrs. Akosua Serwaa wanted this judgment for the purpose of the funeral. Now, if the judge is saying, and the judge said, no, I'm not going to give you injunction. I'm going to hear the case before, I think it was meant to be the 16th of November, something along those lines. Or I don't know, 20th or something of November. So the funeral is on the 6th of December. So there's no need for the injunction. So there was no injunction. So if without injunction, the judge determines that she can't provide a judgment until January, then the remedy that Mrs. Akosua Serwaa went to court to seek, she's not going to get it. She's not going to get that remedy because the funeral will go ahead and Mr. Penny will do what he wants to do.
Well,
the judgment,
I understand you, but it's arguably, so it's fine. I mean, that's fine.
I mean, what I would say is, I think from their perspective, because and also the reason why seeking another injunction would have been a problem is because in the judge's determination to lift the injunction, she also said that it's not the wife that wrote to me, it's the family that wrote to me. So because you know that the family are the one who have to me, then and the likelihood of you getting injunction would be slim. I'm not saying that. Let me be honest with you. If I was a lawyer, maybe I would still fight it, and I would still be like, give me injunction no matter what. But I can.
Thank you. I get I appreciate the fact that you also consider my point.
I can see the point exactly, yeah. But I can see, professional lawyer thinking it's not great court, behavior, and so that's the reason why I can totally see from where, because you get to see the judges all the time. You do not want to do anything that can impact on the relationship or the way you are perceived in court. So I can totally see Lawyer Kwesi thinking, oh well, okay, I can reduce my questioning and move on because I want a judgment rather than seeking injunction. That's what I was trying to basically say. I know someone came to ask a question,
okay. But I've been researching this while you guys spoke, right? And where's himself? Okay, himself is here. You see, there are issues. Juma mentioned that at some point they wanted to call witnesses and expert witnesses, and then the judge objected to it. That is partly true, but it depends on the context for which they were going to call the witnesses. If you look at paragraph 78 of the ruling, at some point it was about signatures. It was about signatures where the counsel for the plaintiff were making some objections that when I read it, I didn't understand. They were saying that there's Mama Akosua Serwaa's signature on her passport, which she submitted as Exhibit CFK1, was different from the one she had given to the power of attorney to Mama Georgina. And so the defendants were objecting to Madam Georgina's power of attorney. Those were the parts where the judge said that the court is not, they will not call any witnesses, they will proceed as planned because they gave other ruling. And so you could check the 78.
No, maybe it's not like that, please. I don't think what you're saying. The court never said they will not call witness. They did not even raise the witness part. The court said the court is not an expert on signatures. So they are going to move forward. So you will accept the signatures.
Yes.
But I never says because of signatures on a part, and we should go and call a witness from Canadian embassy, was it German embassy? Who would do that?
No, but
there's a signature. So yes, what we are talking about is the marriage certificate. That's whereby they wanted to call an expert. It wasn't on the power of attorney. Power of attorney is a normal document. Why do you go?
Okay, hold on, Kobe. That's it. The argument you are making.
Yes.
The argument is defeated because the judge in the ruling, let me find it, said that the plaintiff could have called. Could call. It doesn't mean that statement means that it is the plaintiff's discretion not to have called.
But not on the power of attorney. That's what I'm saying. So let's go back on the marriage certificate. But what you are trying to do is you are saying that on that power of attorney side is whereby the expert arguments come in. And I'm saying
I was giving cases where the judge overruled them that there will not be any. They don't need to have any.
Okay, the second one. Which one will be? Which one did he overrule? Can you give me another part where the judge overruled?
Based on signatures or based on
an expert.
Okay, hold on. Some of these things, because it's a court document, sometimes it takes me some time to just figure it out.
Yeah.
Okay, sure.
So lawyer and the tennis. So people have this argument about bringing fresh evidence. Please, can you guys explain a little bit how courts accept evidence, fresh evidence, or new evidence? That word, what does that mean? Please?
Fresh evidence on appeal. Okay. Let you matter because jurisdiction is different because you go by because of appeals. It's literal. So
yeah. So essentially, generally, the rule is that you don't produce new evidence. That's general. The general rule is that you look at the evidence that was produced at the time. There's no bar to produce evidence, but there is a test that you have to meet before you submit the new evidence. So the normal general rule is that you just you ask for it's a submission. You show where there's been an error and you meet the test, and that is it. But there is no bar specifically for producing evidence. I'm not going to go into legal bit that you have to meet to be able to show that allowing the new evidence is in accordance with. Sorry.
In simple terms, please, our audience and Ghanaians, most of us, we don't know the law. So can you explain in simple English or somewhere by we can educate the people?
So essentially, you may be able to produce the evidence where it is significant evidence, and it's just for that evidence to be produced and to be submitted in evidence, and you did not have control of that information at the time of the hearing, but you now do. So, for example, like the wedding video where Daddy Lumba's friend had it in a different state, and when they heard about the judgment, they pulled it and was like, "What do you mean there's no video? And this is the video." And that could be something that they could argue that the video of the ordinance marriage, after the determination, somebody has pulled it. The person who filmed it has pulled it from the archive, and they've now given it to Lawyer Kusi. Equally, it could be the authentication of the marriage certificate. It could be that they can argue that this is significant new information. That after the determination has been heard, the process has now been finalized, and they've now been able to authenticate the marriage certificate. And then they say we all know if all that was required was authentication of that paper, that marriage certificate, and you now have it. It would be good grounds to be able to argue that the court should allow you to submit it, because the reason why you can show evidence that you had put the process in during the first hearing, and now the process has finalized, and you show that it would be substantial, that it was not in your control at the time, and it would make a big difference, and it would allow you to gain justice if the court were to look at it. Does that make sense?
It makes sense.
Yeah.
Lawyer, can you add some?
Cover an appeal there is literal, so rule or you you just read CI 19, that's the Court of Appeal rules. We read my exception a bit in the general rule necessary on appeal, we don't accept new evidence. That's the general rule, and it has an exception. So the exception is let me read it straight from the CI 19. A party may, by leave of the court here, by the permission of the court, allege any facts essential to the issue that has come to his knowledge after the decision of the court below, and adduce evidence in support of the allegations. At the time I don't know, that evidence wasn't within your knowledge, but and once I say way, and these are all these things you have to prove to the court, right? So it comes with a proof. So way. So you file a motion to seek leave, then you file a motion itself to convince the court for you to adduce new evidence before you adduce it. In the court who argue motion now it has a sample. They won't say be accepted this new evidence on appeal, they are fine, or may accept it. So it's part of that.
And not just said, yeah, and yes, say, be yema ubia mfadibia documents nina they were dana. There's a hard rule whereby nobody can bring new evidence or even make that motion. And Tessa.
Yes, except you see, I was entering a big general rule and exception. The general rule is won't mean for BBS, but the exception is the mistake here.
Your state, it does it.
Yeah, so simple. So there's a week.
It's simple, but sometimes best to read the general rule though.
Yeah, crack on.
Okay, thank you very much. I have a question. Some of us we don't have any legal background, but we want clarity for future sake. So I think that when you were speaking, what can it be about time? Honestly, I'm about to go to work. I couldn't catch everything. But this court case, I said based on time, a lot of things we are not able to based on time, no mind to me and find your baby right? But I'm asking you as a lawyer, say, if you go to court now, some of us we have a certain expectations about the judges, right? From the judge, we expect certain things from a judge. We are expecting obey to say, unless say correct me, but say I have nothing to do with law. We see you as Sabia, you are a mediator. And now only say time was going to be something that time was going to be a factor. A bit to me, case, I hope I'm asking the question well. If you know that time bit me a case now. As a judge, what was the best way you think say she could have gone about with it? Because when we say I said 2 weeks, and this case, we've seen say it looked like 2 weeks was not enough for certain things. So and yeah, to say most of the judgments are per the judge's discretion. That's I think that I hope I'm right. And as a judge, as a lawyer, what do you think says? Well, some of us we are expecting the judge could have prolonged or could have told them that I could see you might need time, because I've been to court before. Sometimes I sit at jury, that I go for court jury, and I've seen a judge tell somebody that, go and do this, do that, and come back to me. But in this situation, it sounds as if even if the judge knows that, because one say, what is the purpose of the court? What is the purpose of finding justice? You get what I mean? Yeah, Titi Bibi to say technicalities and also more lawyers, no one every thing about it. But for us to find justice, which is the reason why we come to court, and I said the court was came about, as a judge, as a lawyer, what do you think that the judge could have done better to have helped this situation? Because at the end of the day, if the marriage certificate was truly fake, even if you give her 1,000 years, she cannot prove it. If the certificate cannot be authenticated, even if you give her 1,000 years, she cannot do it. So what do you think that the judge could have done better? Because some of us, we still have some expectations from the judge. Yeah.
Question, you see, you can't blame the judge. Why? Because when you guys are having a case, right after pleadings closes, you guys will file your application for directions. You guys will you do your CMC, and you set dates for trial. All these three things. It's not only the court that is deciding. It's the three parties. The plaintiff, the courts, and the defendants. It's nipa miensa na yes no. So say be in favor wa. So be custom. And that's all a lawyer now because in your application for directions, Ube state this one pre-trial checklist Ube state say be a present witnesses say me spend the time say they are cross-examine way, Maybe I'll need 2 hours or 3 hours or 2 days to cross-examine my opponent's witness. And who state be so we prepare the case itself. It's not like you have your hands tied behind your back as a party.
No, the thing is that, lawyer, I won't say, I believe, even though certain documents need to be authenticated, and I said there's a process in which a document will be accepted in court, I believe, based on what I've learned so far, I believe, the document that was presented, it could have been, it can be accepted, but at what point now? Based on maybe cut time from the judges, maybe speaking say a judge, because if maybe certain documents could be accepted, but I don't know the reason why I authenticating, but if you want the thing authenticated, it might not be done. It could you can't do it within that 2 weeks, as a judge, what could she have done? I know somebody is saying that you can't. The judge can't help, but I mean, what's the purpose of the judge being there?
The purpose of the judge being there is the judge is just one way or the other an empty vessel. So, so even if
the judge knows that this thing, even if they know that it's just maybe if I've given them, let's say, a week or something like that, let's say lawyer Kusi did not know about it. Maybe I've given them another week, they could have proved it, which would have let justice be served. You could still go ahead and pass judgment.
I didn't get the last.
No, I'm trying to say, okay, as a judge, if say, okay, this document that has been presented, if I give them, let's say, if they have time to go and authenticate it, which 2 weeks maybe they cannot do the authentication. I don't know much about it. So as the judge, if you know that, do you think that it's okay to just pass judgment instead of maybe prolong it a little bit to give them time to go and bring that authentication if truly it needs to be authenticated?
So
truly it needs to be authenticated. You as the party bring it.
The lawyers could have asked for extension.
You see, all that we are talking about is you that you are proving your case, not the court. The authentication, if you is a rule, is in the Evidence Act that you need to do it. It's not the court that's saying do it all. Per the rules, before you even start the game, you know that this thing that you are going, if it's not authenticated, the other lawyer won't sit aloof for you to enter with this thing. You get it? So I can't blame the court on this side. You are coming. You should get your arsenals very right. So if you get it very right, when it gets there, it's cause almost authenticate here then and almost certify at then Sebio. By this time, this wouldn't be the ruling. And I almost certify. It's still crown still. So almost certify. Maybe a defense, maybe I'm going to put out defense because I bet me I'm a expunge marriage certificate. I've already said, say, this judgment is some way, somehow. Marriage certificate is one part, and the other part is the performance of the marriage. Performance of the marriage, it should have been. That's where your lawyer could see. I didn't get him say by any means. Also, a lawyer or Germany, and an expert, and then about Ghana, and what about prove the foreign law, no? Because I know expenses kind of mobile, but ube lawyer or Germany, how are you qualified? No aba chishem say na German na we siche. Na nko omo timi ye sample and a certificate now for they had another leg to what? To stand on. But omo fa professional na and I expert witness na and a certificate na so e failure. Then a ma judge the chance on no be cho say ne at the moment me improve more several ordinance marriage. You get it?
Now, Lawyer Botan, can I just ask a question? For ordinance marriage, there is no need for you to prove any one.
Let me tell you
something. You have sexual intercourse one time.
No.
No, I'm just trying to check. I'm just trying to confirm this because it may be in the tradition and customs, but I want to be very clear. Even in Ghana law, once you go through your first time you have sex, for ordinance marriage, you consume it. For ordinance marriage, you can live apart for 50 years and there's the marriage is still subsisting. The only way you can prove that an ordinance marriage is no longer subsisting is through a court order. Without that, and so that's probably where the essence of complacence became on a certificate, because with ordinance marriage, and it's not only you that've said that to me. I've had a debate even with senior people within Ghana, and then they're like, "Oh, okay," because when you look at Cap 125 or 129, it's really Is it 127? I think 127.
Yeah.
It really goes into that, and it's very clear, and it's the same thing with like UK law and everyone law, which is that once that is you can you have that period of thing and there's nothing to say that the marriage is void. And by other means or fraud or whatever, then by that time, it's like that is all that is required. The fact that you don't live together or doesn't break it might give you grounds for divorce, but it doesn't break the marriage, because they see ordinance marriage like a contract thing, and the only way you can dissolve it is through a petition to court and for them to declare that it's dissolved. So that's the reason why I'm a bit. So with ordinance marriage, I think Ghanaians always ask that, but with ordinance marriage, there is very strict rule that the only way you can dissolve it doesn't matter. I mean, there's a lot of discussions around, the abandonment. It's not even relevant with ordinance marriage, because
I won't cut you short, right? But when I say performance of marriage, how do you understand it?
So performance of so for example, when this is where it gets really like confusing for me in the way the Ghanaian lawyers think. Now, performance of a marriage, when it comes to ordinance, in UK or in Germany, there is no even in Ghana, there is no set rules insofar as how a marriage should be performed by either party, aside from one thing, which is the whole thing about you must have sex within a certain period.
When we say performance, I guess where you are getting confused.
That's what I'm getting confused. Yeah.
That's the way we say performance of marriage. It's not about somebody's duties in the marriage or not. Yes, that's where you are getting confused, and it's fine. Literally, when somebody says performance of marriage, the first thing I dream because when they say, "Oh wow, I read him then," or Sevuso Okunu, or Sevuso. No, that's not the meaning of the performance of marriage. The performance of marriage is how the marriage came about. You went through
Okay.
yes, how the marriage came about. So you got married here in this. So the last thing that you use to check is the consummation. That after
Yeah.
the ceremony, you guys have consumed yourself.
Yeah.
You get
Yeah.
it?
Yeah.
Uh-huh.
That makes more
So
sense.
the performance of marriage, the simple meaning is the person you guys were of age. You guys married in accordance with the law. That's the performance. So if you are proving a performance, you can bring Brimpoma. Oh, we had a wedding. The wedding was here. Oh, the wedding was supervised by this. Those that
We did all of
that's the
that.
performance of marriage.
Yeah, so that I mean, I think it's a terminology that makes me think, oh, but
Yes,
yeah,
that makes you
they did that. They bought pictures, and I think the judge was like, oh, if I had video as well, that would be better. So so I totally get it, but the performance thing, I think the lawyer Christie thought he had proven that with the witness statement of the witness who the brother put him on a plane to come to Germany to witness it, all that stuff. So that witness statement was before the court. But I do believe if he had essentially got and I don't dispute that. I think it would have been solid if he had got a qualified lawyer from Germany to calm down, and that wouldn't have been an issue in terms of money. It would have been paid for, and it would have also been solid if he had ignored the judge's discussion with him, which was in court, about the fact that there was no need for them to call an expert embassy in Ghana. If you had bought those two things, I think I agree with you. It would have been.
You see, I'm of the opinion that once we are talking about a case